Good morning, everyone, and welcome. We're pleased to have you with us today. We have three cases on the morning docket, and we will call them in the order in which they appear. Each side has a total of 15 minutes to present your arguments, and if there are multiple lawyers, you have to share that time. The appellant has the right to reserve up to 5 minutes for rebuttal, so that we can program the clock when the appellant's counsel comes to the podium. Please let us know if you wish to reserve time and how much for rebuttal, and the clock will be programmed accordingly. For the attorneys who are here today who frequently come here, we have a larger audience than normal, and I'm sure they're here because of your case. I want you to know that. And they're hoping to learn something from what you have to say today. All of them have been watching the Johnny Depp trial, and they are now equipped, fully informed on all the nuances of law. But actually, two of our very prestigious former law clerks, Miss Fay and Miss Kibler, are here today, and they have brought some interns with them, so we're honored to have you and your interns to observe today. You're welcome to stay the entire docket, or if you choose to leave after any of the arguments, you may feel free to do so. Unless there are some announcements, please call the first case.
Barbara Ann Shelton et al. Versus Mary Eden.
All right. Good morning and welcome.
Good morning, Your Honor. How are you?
Doing well.
Nathan Hunt on behalf of the appellants, Your Honor. If I could reserve 3 minutes for rebuttal. Please.
3 minutes, certainly.
Thank you. Your Honor, this case has been before the court previously in 2020. In fact, it was in front of the same panel that we're in front of today. This case involves Mary Eden, who was one of the daughters of John Farmer, who passed away in 2015. The issue before the court is the same issue that was before the court previously. The decedent, Mr. Farmer, executed 3 promissory notes with Miss Eden on 3 separate dates: September 2009, April 2011, and July 31 of 2011. Those are the 3 promissory notes that are issued today. When Mr. Farmer died, a probate of his estate was opened. Subsequently, the estate filed suit on the first 2 promissory notes because Miss Eden had not made any payment on those promissory notes. The estate sought to recover the amounts of those first 2 notes. The first note was $150,000. The second note was $100,000 plus interest that was provided for in those notes. So the total amount of the first 2 notes was $250,000 plus the interest that had accrued on those 2 notes. The last note from July of 2011 was for $212,919. And the issue before the court, that was before the court last time, was whether the third note acted as a merger or novation of the first 2 notes. Previously, the trial court had granted summary judgment to Miss Eden on that issue. My clients, who are the appellants, who are 5 children of the deceased, appealed that to this court. The court found that the evidence that was before the trial court at the time was not sufficient to find that a novation had occurred, and remanded the case back to the trial court for a full trial on that issue. What's interesting is the court found that even if Miss Eden's testimony that the third note was supposed to be a merger or novation of the first 2 notes was true, her testimony by itself wasn't sufficient to find novation had occurred. The court also found that there was evidence at the first summary judgment stage that the attorney for Mr. Farmer, who passed away, had made some statements about whether a note should be executed to combine the first 2 notes, and the court found that that attorney wasn't involved in the drafting or preparation of any of the promissory notes at issue. So to the extent that that attorney made statements about a combination or merger of the notes wasn't sufficient either, because that attorney wasn't involved in the drafting or preparation of those notes at issue. So the case went back for trial, and essentially nothing really changed at the trial court level. Miss Eden testified at trial just like she testified in her depositions before, which was that my father intended to combine these first 2 notes into the third note. My 5 clients did not have any independent knowledge of those first 2 notes. In fact, they weren't aware of the first 2 notes until depositions were taken in the estate action where those first 2 notes were produced. Miss Eden, on the other hand, with one of her brothers, she was heavily involved in the day-to-day finances of the decedent prior to his death.
Did the estate have all the original notes in its possession?
It did not, Your Honor. Originally, the only note that the estate was aware of was the last note, which was the July 2011
But they
note.
did have an original of that note.
They did. The first 2 notes came to light during my client Timothy Farmer's deposition. The other preceding note came to light during the deposition of Clyde Richard, who was the estate attorney. So the first time the estate became aware of those first 2 notes was during these depositions, and then lawsuits were filed to enforce both of those notes within 1 year of the estate discovering that those 2 notes existed. So before that time, the estate was only aware of this last promissory note from July of 2011.
And
Now, I'm sorry, go ahead.
was there any payment made on any of the 2 earlier notes?
There was not, Your Honor. There was not. The original testimony from Tom Farmer, who was one of the co-executors with Miss Eden, was that he thought the reason the third note was for a less amount of money was because there were payments made on the first 2 notes. But Miss Eden testified that she had not made any payments on the first 2 notes. The accountant also said there were no payments made on the first 2 notes. So there were no payments made on those first 2 promissory
How
notes.
did Miss Eden treat the alleged forgiveness of the deadness on her tax returns?
Your Honor, I do not know that answer. I don't know how.
If there's forgiveness and deadness income, that would have to appear on her tax returns. So no one introduced her tax returns?
They did not. The decedent's tax returns were introduced at trial, Your Honor. And the reason that was important was because one of the findings the trial court made was the fact that there was only proof that Miss Eden borrowed $250,000. There wasn't proof she borrowed this last $212,000. The proof came out at trial that there was $247,000 from that exact time period that was unaccounted for. Miss Eden was the one who subsequently had a power of attorney over her father. She was on a bank account with her father. She was the one who had access to this. She conducted all sorts of transactions within that bank account she shared with her father. She would have had knowledge of where the $247,000 was. The accountant would have had knowledge of it. Neither of them could account for where that money was. The reason that was important was to show that there was sufficient money available to make that third loan. She admitted she borrowed the $250,000. Miss Eden argued the last $212,000 was just a merger of the first 2 notes, but there was sufficient money there to account for the third loan, and Miss Eden couldn't account for where $247,000 went. The accountant could not account for where $247,000 went. So,
Talking about the amount of money loaned, 2 of the defendant's siblings, John Farmer and Timothy Farmer, testified that their father only loaned Miss Eden $250,000. And one of those 2 siblings is one of the plaintiffs.
So, Your Honor, Tim Farmer's deposition, I believe respectfully, the way it was presented might have been a little misleading.
Was it corrected on cross-examination?
I believe I did correct it on cross-examination.
And to what did he say? I'm sorry, I was wrong?
We essentially said that it was, I think it's a 1-letter, note versus notes. He said there were multiple promissory notes, not just one promissory note. And I think the key there was Tim Farmer wasn't involved in the drafting or preparation. He didn't even know about these notes until his deposition when one of those notes was introduced. So he didn't have any knowledge of these notes.
Somehow, during testimony, he convinced both counsel that he had personal knowledge, or there should have been an objection as hearsay.
Your Honor, Tim Farmer's deposition was essentially, or his testimony was essentially that he knew at one time there was $250,000 that was loaned to his sister Mary Eden.
But it's my understanding he said only loaned $250,000.
I believe that was Tom Farmer. There's a Tim and a Tom. I believe that was Tom Farmer who said.
My notes may be wrong, but the certified public accountant, Irvin Brown, also said the decedent only loaned $250,000.
Correct. And I think that's key, Your Honor. When this case was before the court last time, the court found that even if you took the estate attorney, Clyde Richards' testimony to be true. He wasn't involved in the preparation of the notes. He didn't know anything about them. The same thing for the
Well,
accountant.
now,
Your
wait a
Honor.
minute. You say the attorney didn't know anything about it?
He did not. He was not involved in the
Well,
preparation.
didn't he meet with the decedent and write a letter saying that what you're proposing or what I'm proposing is that this, I would suggest any money Mary owed be set up on a new note payable in monthly installments for 5 years, but with payments set lower if the note was over a longer period. Isn't that letter from the decedent's attorney
It is, Your
completely consistent with the defendant's testimony?
Your Honor, Mr. Richard, the estate attorney, was asked about that, and he said he has no idea if there was any follow-up to that. He never saw a note. He didn't draft the notes, which is interesting in and of itself. They had a
But
person at the bank.
this was written in response to a conversation with his client, the decedent.
That is correct, Your Honor.
Okay. Now, the standard of review here is we assume the evidence supports the trial court's finding unless the evidence preponderates against those findings of fact.
Correct.
The trial court made specific findings of fact that 2 of the siblings, one of whom is a plaintiff, said the decedent only loaned $250,000. The CPA said the decedent only loaned $250,000, and the attorney for the decedent said this will be a new note just to catch up for the monies that are already owed.
Right.
What evidence do you have that preponderates against the trial court's findings?
As far as Mr. Richard's letter is concerned, would be the same as last time, Your Honor. He didn't prepare any of the promissory notes at issue. He did not have any independent recollection of those notes. His file only contained the 3rd promissory note that was executed. It didn't contain either the first 2 promissory notes. And just as this court found last time, he didn't draft those notes. He did not have any independent knowledge of what those notes contained.
But that was a summary judgment. So the burden was on the movement in that case. This is after a trial. I mean, our review here is totally different.
I still think when the court, and I've reviewed the opinion from the court this morning, the court still found that even if you took what was said to be true, which is Miss Eden's testimony that it was a combination of those first 2 notes, it still wouldn't be sufficient. If Mr. Richard's letter in and of itself wouldn't be sufficient, even if you took it to be true. So I think in that regard, this letter in and of itself, when Mr. Richard wasn't involved in drafting or preparing the first 2 notes, is definitely key. He had no involvement in any of the notes. He wasn't even aware of
So
all
it
the
sounds like your
notes.
argument here is not that there's not evidence or the evidence doesn't preponderate against the trial court's finding, but rather, even if all the evidence is true, it's still not clear and direct enough to show novation. Is that your position?
It is, Your Honor, and remember, novation is, the burden is on the party alleging a novation occurred, and you have to look at the intent of the parties, which is going to be the issue here. Our argument in our brief, which is sort of a forest for the trees approach, which is really that the fact that the first note contained a provision that said it can only be modified in writing signed by the parties. All of the parties agree, including Ms. Eden, that there was never a document executed that stated that this is a revocation of the first 2 notes, or this cancels or extinguishes the first 2 notes. Nothing was ever done to state that. There's just a 3rd note for a different amount. I think it's also key to show that the 3rd note doesn't equal $250,000. It equals $212,000. So the math doesn't even add up. That's one thing the trial court said is, well, the $250,000 and the $212,000 are substantially equal amounts. Well, respectfully, they're not. There's about 15% difference or $37,000 difference in those 2 notes. So the 2 notes aren't for substantially equal amounts. They're for a significantly different amount. And the money was available to loan Miss Eden that additional amount of money that was there. She was the one in the best position to know the finances and had access to all of that. Thank you.
All right, thank you, Mr. Hunt. We'll hear from you further on rebuttal. Mr. Johnson, good morning, sir.
Good morning, Your Honors. Your Honor, while I have prepared my outline and ready to argue, I will answer the questions that the court did ask of Mr. Hunt. Your Honor, you first asked whether or not the estate had all of the notes in its possession. The answer is yes. There is testimony from Miss Eden that on May 23rd, she and her brother and her father delivered the first 2 notes to the attorney, Mr. Richard, on that day, May 23rd. So he had those two in his possession.
Now, did he have originals or just copies?
They took copies to him.
Okay. I mean, the reason why I asked that, obviously, if an original note is missing, that might suggest that it has been destroyed.
Yes, and there was never any question about the original notes. I believe we had the original notes during the actual trial when the cases first began 5 or 6 years ago. The third note is the one that Mr. Richard brought to light in one of the depositions, and it was in his file. At the time Mr. Farmer died, the plaintiffs and my client went to see Mr. Richard to hire him to represent the estate. Because of a conflict, they had to hire a second attorney, and he therefore sent his file to that second attorney, and all 3 notes were contained in that file. The second question was
originals
asked,
or copies?
Just copies, Your Honor.
Okay.
The second question that was asked by the court is whether payment, did she make any payments on the previous notes? And Mr. Hunt said no. There was a trial held before Chancellor McMillan on this, and Chancellor McMillan found that the decedent had granted his daughter a forbearance on paying those notes for a couple of years. So after the trial, he granted our motion for summary judgment, and he ruled that there had been a forbearance granted by the decedent. So she was not allowed or required to pay those notes until after the decedent's death. And so that was clear testimony at a trial.
What about the fact that the amount of the first 2 notes doesn't equal the amount of the last
Very
note?
good question, Your Honor.
Thank you.
There is testimony at the trial by Ms. Eden with documentation supporting that. She said that the notes totaled $250,000. When they prepared the third note, she testified that her father gave her a $38,000 discount because she had purchased a vehicle. And at this time, Ms. Eden was one of the siblings who was caring for her father since 2011, 2012. They were taking him around wherever he wanted to go. And because she had purchased that vehicle, he said to knock that amount off of the $250,000. And we put into evidence, payments of that and proof that she had actually purchased the car. So she testified that that's why it was about $212,000.
So was the vehicle titled in the borrower's name?
It was her vehicle. She bought it.
So
And
she got credit for a vehicle that she bought for herself against the
that's
note.
what her father did. And he said, because you're taking care of me.
But she was driving him around.
Yes.
He
in
bought
that
it to
vehicle.
transport him.
Yes, that's what she was doing. And so that was testimony there. The third question that the court asked was, well, how did she treat these payments that were forgiven on her tax returns? We don't know. That never came up. That even during the first trial, that issue never came up. So we don't have the answer to that. And finally, Your Honor, you asked about Tim Farmer. Did Tim Farmer testify about the $250,000? There is testimony Tim Farmer gave in his deposition and at the trial. Tim Farmer said in July of 2011, which is when this third note was created, he said, I was sitting in the truck with my dad, and my dad said to me, I gave her $250,000, period. That's how he testified. That's what he said. And so he was pretty clear about that. And I asked him, did your father say he ever gave her any more money? He said, no, it was $250,000, period.
And Tim Farmer is one of the plaintiffs.
Correct, Your Honor. Tim Farmer is one of the plaintiffs.
Now, is it correct that John Farmer, one of the siblings, did not join in as a plaintiff?
John Thomas Farmer, he was not one of the plaintiffs in this case, Your Honor.
He's one of the siblings.
He's one
but
of the
he
siblings.
opted out.
Right. He is Tom Farmer.
And he too testified that his father only loaned $250,000.
Yes. As a matter of fact, Tom Farmer's testimony, when Mr. Hunt says nothing changed from the previous matter, the court's right, that was a summary judgment matter. This was an actual trial. What actually changed was in the trial, there was testimony by Tim Farmer, and by Irvin Brown. As opposed to the summary judgment matter, it was only the testimony of Miss Eden that we used. So at the trial, Tom Farmer testified that he was at Larry's restaurant the morning that they signed the promissory note. The previous 2 promissory notes were signed at a bank, at Regions Bank in September, and there was a banker there, Miss Chowning. Miss Chowning is the person who prepared the promissory note. The decedent and Miss Eden went to that bank. They signed the promissory note. Ms. Channing gave Ms. Eden a check for $150,000. The second note that was signed occurred on April 7th of 2011. They were then at Commerce Union Bank because Ms. Channing had changed banks. She went from Regions to Commerce. She prepared the second note. They went to that bank and they signed a note. Ms. Channing gave Ms. Eden a check for $100,000. When the third note was signed, it was at 7 o'clock in the morning. The parties were met at Larry's Restaurant in Springfield, and Tom Farmer happened to be there. And he saw his father and Miss Eden come into the bank, and his father told him at that time, Mary owes me $250,000, and we're just going to combine those into one note. That's what he said to his son that morning. Mary owed me $250,000. That's how Tom knew what was going on, and he testified to that in a deposition. Now, Mr. Farmer, Tom did not testify, did not appear personally at the trial. I believe he was having back surgery, but we entered his deposition into evidence. That they cross-examined him before. When they took his deposition, they never impeached him. They never showed that he was biased. They never showed that he wasn't credible. And the judge accepted his testimony.
And John Thomas was also a beneficiary of the estate.
He was a beneficiary. All of the children were beneficiaries of the estate.
Isn't he the co-executor or executor?
He was one of the original co-executors, yes, Your Honor. And then the third person who testified, whose testimony was introduced, was the accountant, Mr. Irving Brown. And Mr. Brown testified that he had been the decedent's attorney from 2001 through his death of 2015. He said that the decedent confided in him. He did his taxes every year. He testified that the decedent told him that he only loaned Mary $250,000. And so the accountant knew that that was a $250,000 loan out. The reason that's important, Your Honors, is because you're right. If you add up the three notes that they're talking about, it totals $462,000. And they're saying that that's what was owed. Mr. Farmer, the decedent, never told anyone that she owed him $462,000. He told his son, Tom, she borrowed $250. He told his son, Tim, she borrowed $250. And he told his accountant that she borrowed $250,000. And the judge allowed that testimony because he said that it would be against the pecuniary interest of the decedent to say it was $250,000 if it was in fact $462,000. So that testimony was admitted into evidence. So the trial court, after that, the trial court found 27 undisputed facts. And also, the court should be aware that during the trial, the plaintiffs presented no one who put on any evidence about what the intent of the decedent and Miss Eden was when they entered into that third promissory note. Not one of the plaintiffs was able to testify. Barbara Shelton testified that she didn't know anything about it. She didn't know what they intended. The other sister, Peggy Duffer, testified that she didn't know anything. She didn't know what they intended. She had no facts whatsoever. So the facts that were presented into evidence was totally undisputed. No one disputed what Tom Farmer said. No one disputed what Tim Farmer said. No one disputed what Irving Brown said. And the trial court found all of that evidence to be compelling and to be clear and convincing. And I think the court is right. When you apply the standard, which is a presumption of correctness on the findings, they have failed to produce any evidence to rebut any of those findings. And so we think that they have simply not overcome the presumption of correctness that accompanies this case. Ms. Eden even testified clearly from the witness stand that she expected for those first two notes to be torn up. She intended for the July 31st, 2011 note to extinguish the first two notes. And I asked her, well, what did your father intend? She said he expected the same thing. That's what we were doing. He expected it to be torn up, and he expected it to combine the first two notes into the first note. And that's what he said to his son that morning when he walked into Larry's Restaurant. Why would they negotiate the first two notes at a bank and receive checks, but then negotiate the third one at a restaurant at 7 o'clock in the morning when the bank's not even open? No money exchanged hands. Now, I want to address this question where they're saying, well, there was money available. Well, they testified that there was money available looking at his investments. Mr. Farmer, the decedent, was an astute investor. He invested money in various instruments. He also had an account with Morgan Keegan, and he had an account with Commerce Union Bank. In fact, Your Honors, when he met with his attorney on May 23rd, he told his attorneys, I have about $320,000 in my Morgan Keegan account, and I want to make sure that's taken care of. He also had about $70,000 to $90,000 in the Commerce Union Bank account. Why is that important? Because if you look, and this is in the record, all of these statements and everything, all of these statements from Morgan Keegan and Commerce Union Bank, if you look at those documents, after they signed that promissory note on July 31st, 2011, approximately the same amount of money was in that Morgan Keegan account. I believe it was $321,000 still in that Morgan Keegan account when he signed it. Approximately $94,000 was still in his Commerce Union Bank account the day he signed. Ms. Eden testified, I did not receive any more money from my father that day. I did not receive $212,000 from my father. I received a total of $250,000. So the appellants testify, and they write in their brief where the money was, quote, available. That's the word they use. But they never say the money was given to Ms. Eden. They never say that she received it in the form of a check or cash or anything. They just say money, quote, was available.
Did he not say there was some money unaccounted for?
That's what he's talking about.
That's what he's talking.
What he's talking about is some of Mr. Eden's prior investments. I believe in 2009 and 2010, he liquidated some funds and he reinvested those. We had someone to testify that he actually reinvested those monies. Well, some monies, we don't really know what happened to it. I don't really understand why they're saying, money is missing. There's no money missing. I even asked Miss Barbara Shelton on the witness stand, your father was an astute investor. Yes, he was. He did invest his money. I said, well, what did he do with this money that you're claiming is missing? I don't know. What, did he bury it in the ground or something? He wasn't the kind of person who would do that. She says, I don't know. He could have given it to Mary, my sister. That's what her testimony is. Well, that's not testimony. That's not evidence. And, Your Honors, we simply think that they have failed to carry their burden. We think that the trial court was correct when it found 27 undisputed facts and ruled that Ms. Eden carried her burden of proof to establish that the third note was a novation and cancellation of the previous two notes. And we think that the trial court's decision should be upheld. With the remaining time, I'll answer any questions that the courts may have.
Hearing none, thank you, Mr. Johnson.
Thank you, Your Honors.
Mr. Hunt, rebuttal.
If I could just address a couple of issues that Mr. Johnson brought up. The vehicle, I think, is a key issue. Ms. Eden testified at trial that the difference between the 250 and 212 was a vehicle that she had purchased. The evidence she introduced, the vehicle was $36,394. Well, the difference in the two notes was over $37,000. So there was a $600 difference there, which I think is key, because if truly the only reason the note was less was because she purchased a vehicle, you would think the amount of the third note would be equal to the difference of the vehicle price, and it wasn't. There was a $600 difference there. So that testimony wasn't consistent at all with the fact that I borrowed, if you're saying the difference
What was the cost of the car?
$36,394.14.
Was that the sticker price?
That was the amount that was introduced that she paid for it, Your Honor.
Okay, so that includes taxes and fees and Lord knows what else they put on cars now.
That's correct, Your Honor. That was the only evidence introduced.
Undercoat and, yeah.
That's correct. And the difference in the notes, though, was over $37,000. So it would just seem logical if that was the difference, then that would be what the note stated. And it's not what the note stated. There was over $600 difference in those two amounts. And not to mention, Tom Farmer didn't say anything about the vehicle. He said he thought it was because of interest payments that Ms. Eden had made on the first two notes. So there was definitely inconsistent testimony in that regard. Timothy Farmer, who's one of the plaintiffs in this, his testimony was, when I talked to my father, he said, I have loaned your sister $250,000. But we don't know the time frame that happened. We don't know if he loaned her additional money after that. There was no testimony.
So did he not recall? Was he asked when that conversation took place?
Did not recall the time frame that conversation occurred, Your Honor. So clearly there could have been additional monies loaned after he had this conversation. There was a gap between when the first and second and third notes were executed, and clearly there could have been additional money that was loaned at that point in time. There's $247,000 that was unaccounted for. Miss Eden was on a bank account with her father. She had access to that money. The reason my 5 clients didn't know anything about that is because they didn't have access to that. They did not have a power of attorney over their father like Miss Eden did. They didn't know about his day-to-day finances.
Well, did you examine the withdrawals from the bank account? Were there suspicious withdrawals? How can you say she took this money?
There were very suspicious withdrawals, and that was part of the reason.
Is that in the record?
It is in the record. There were bank statements. They were introduced into the record, Your Honor. One reason she was removed as a co-executor of the estate along with her brother was because of those suspicious expenditures.
No, she was removed because of a conflict of interest.
She was, Your Honor.
Because the estate wanted to sue her.
That's correct.
And she can't represent the state suing herself.
She was actually removed before that. The estate wasn't even aware of the promissory notes at that time. She was removed for other
Well, didn't
reasons.
someone on her behalf early on write a letter proposing the payout
They did.
before she was removed?
That's correct.
Okay,
That's correct.
so that sets up the conflict of interest.
It did, Your Honor. There were a number of reasons she was removed. That was one of the reasons.
All right, thank
Thank
you,
you.
Thank you, Mr. Hunt and Mr. Johnson, for your arguments. We will take your matter under advisement. Call the next case, please.